Assalamualaikum and good day. We are from Group 2. My name is Muhammad Shahriz bin Shahezan and my matric number is 288972. Today we'll be presenting about the Malaysian judicial system, specifically the superior courts. The Constitution separates the Federation's authority into three parts: executive, legislative, and judicial. The Constitution provides three organizational means to exercise the relevant authority. A court system distributes judicial power. The courts are the supreme branch of government. They are ultimate in that they are uncontrolled. The courts can rule on the legality of federal and state executive activities. They can also interpret the meaning of any section of the federal and state constitution. Next, the federal constitution exempts judges of the High Court from the general rules set out in Article 132, Clause 2A, that a member of the public service holds office at the pleasure of the Yang di-Pertuan Agong in order to ensure the court's independent in discharging their responsibility without fear or favour. Judges do not serve at will. The Yang di-Pertuan Agong may dismiss them only for valid reason of misbehaviour, insanity, or other causes. They can only be removed from office by a tribunal of at least 5 judges of the Federal Court or the Court of Appeal and the Chief Judges of the High Court. Article 125, Clause 3, Clause 4, and Clause 5 of the Constitution provide for removing a judge. Next, the court's division and hierarchy of judiciary. Malaysian courts are currently divided into two categories. First is federal courts, the inferior court or subordinate courts, which are session courts, and also first and second class magistrate court. But today we will focus on superior courts. Federal courts are organized in three divisions. Federal court followed by Court of Appeal and two high courts. Except for the Sharia court, the Malaysian judiciary is federal. It has three-tiered superior court. The federal court is Malaysia's highest and final appellate court. The Federal Court consists of President of the Court, titled Chief Justice of the Federal Court, the Chief Judges of Malaya and Sabah and Sarawak, and 8 other Federal Court judges. The Federal Court will hear and decide cases with a panel of 3 judges, or a larger number as determined by the Chief Justice. The Court of Appeal was formed in 1994 and has its principal registry in Kuala Lumpur. The Court of Appeal has a president and 10 other judges. The Court of Appeal only has appellate authority in criminal and civil cases. Criminal and civil appeals are covered by Section 50, Clause 1 and 67, Clause 1 of the Court of Judication Act 1964. The High Court of Malaya, with its principal registry in Kuala Lumpur, and the High Court of Sabah and Sarawak, with its principal registry wherever the Yang di-Pertuan Agong deems fit. Article 122 AA of the Constitution designates the Chief Judge of Malaya, previously known as the Chief Justice of Malaya, as the head of the Malaysian High Court. In their respective territories, Chief Judges are members of the Federal Court and heads of subordinate courts. Now, I would like to pass to Haqif. The floor is yours.
Thank you, Shahriz. My name is Muhammad Farish Hashim. My matrix number is 288300. Today, I'm going to talk about Federal Court. Federal Court is the highest court and the final appellate court in Malaysia. Its decision binds all the court below. Previously, after independence and before prior to 1895, the final court of appeal in Malaysia was the Privy Council. It was then abolished and replaced with the Supreme Court in 1985. And finally, in 1994, the Supreme Court was renamed as the Federal Court. Federal Court has 3 types of jurisdiction, which are appellate jurisdiction, original jurisdiction, and advisory jurisdiction. For the appellate jurisdiction, under the Article 121 Clause 2 of the Federal Constitution, confers the power to the Federal Court to determine any civil and criminal appeals from the decision of the Court of Appeal relating to matters decided by the High Court in the exercise of its original jurisdiction. That means the appellate jurisdiction of the Federal Court was to determine the cases appealed from the Court of Appeal, which the cases was decided earlier by the High Court. Okay, so this is the illustration. Let's say there is a case which was originated from the High Court. And the High Court has made the decision of the case. However, the parties of the cases are not satisfied with judgment, so they can appeal to the Court of Appeal. After that, Court of Appeal will make the decision either against or approving the judgment made by the High Court. So, if the parties are not satisfied with the judgment again, it will then appeal to the Federal Court, and the Federal Court will make the final decision of the cases. So this is an example of the appellate jurisdiction in the federal court. The next jurisdiction of the federal court is the original jurisdiction under the Article 128 of the Federal Constitution. There are three matters on this original jurisdiction. That means the following cases will originate from this court. These cases are not going to bring to other court. Only the federal court has the jurisdiction to solve the cases. So, what are the cases? Any question whether a law made by a parliament or by the legislature of a state is invalid. It is the jurisdiction of the federal court to decide in terms of the validity of the law which was made by the parliament or by the state legislative assembly. On the ground that it made a provision with respect to a matter which they has no power to make such law. As an example, parliament jurisdiction is make law relating to the federalist. However, the parliament make law relating to the state list, or maybe the state legislative assembly make law relating to the federalist. The state legislative assembly has no power to make such law, so the law was invalid. This is the jurisdiction of the court to make decision in terms of the validity of the law. The second matters of the original jurisdiction is the dispute between state or between the federation and any state. So, if there are any dispute on certain matters, maybe in terms of administration, so in this situation, it will be brought up to the federal court. No other court can try or can solve this kind of cases because these are the original jurisdiction of the federal court as in provided under the Article 128 of the Federal Constitution. And the third matter of the original jurisdiction is to determine any question arises in other court as to the effect of any provision of the Constitution. If there are any issues relating to the Constitution which was brought up in the other lower court, so this matter will be brought to the federal court. No other court can solve on this matter. So these are the three matters that must be originated in the federal court. The last jurisdiction of the federal court is advisory jurisdiction. So, if there are any constitutional question, the matters will be decided by the federal court, where federal court will give advice to the Yang di-Pertuan Agong by virtue of the Article 130 of the Federal Constitution. The Yang di-Pertuan Agong may refer to the federal court for its opinion on any question as to the effect of any provision of this constitution which has arisen or appears to Yang di-Pertuan Agong. This jurisdiction only for the federal court by virtue of this Article 130 of the Federal Court. Thank you. So I will pass the floor to the Faiz.
Thank you, Haqif. My name is Faiz Haziq bin Haimi, matrix number 288154, and I'll be explaining about Court of Appeal. The Court of Appeal of Malaysia was established in 1994 to serve as a second-tier appellate court due to the abolishment of Privy Council back in 1985. The Court of Appeal is the second highest court in Malaysia below Federal Court. It is chaired by the President of the Court of Appeal, which is the current President of the Court of Appeal is Tan Sri Rohana binti Yusof. The members of the Court of Appeal or the judges are appointed by Yang di-Pertuan Agong with the advice of the Prime Minister, and their membership is provided under Article 122A of the Federal Constitution. Now we shall take a look at the Court of Appeal's jurisdiction. It does not have original jurisdictions, but however, it does have appellate jurisdiction in both criminal and civil matters. As for the criminal matters, it is provided under Section 50 of the Code of Judicature Act 1964, in which it is there are two subsections. The first subsection, subsection 1, In respect of criminal appeals, the Court of Appeal shall hear and determine any appeal against any decision made by the High Court in its original jurisdiction or in its revisionary or appellate jurisdiction made by the Sessions Court. And as for the second jurisdiction is with the leave of the Court of Appeal against any decision of the High Court in the exercise of its appellate or revisionary jurisdiction in respect of criminal matters decided by the Magistrates Court, in which it is only confined to the question of law. And as for the civil matters, it is provided under Section 67 of the Court of Judicature Act, in which it is provided that the Court of Appeal shall hear and determine appeals from any judgment or order of any High Court in any civil cause or matter. Now we shall take a look about non-appealable matters. It is provided under Section 68, subsection 1 of the Court of Judicature Act, in which it is provided there are 4 situations or matters that are not appealable. Number 1 is if the amount or value of the subject matter of the claim is less than 250,000, except with the leave of the Court of Appeal, and the amount is exclusive of interest. Second is the judgment or order is made by consent of parties, in which both of the parties involved in the case agreed to the decision made by the High Court. And then next is the judgment or order relates to cost only, which by law are left to the discretion of the court, except with the leave of the Court of Appeal. And finally, where by virtue of any written law, the judgment of the judgment or order of the High Court is final, in which no appeal shall be made to superior courts. And now I will pass the floor to Ardina to explain about High Courts.
Hi, I'm Ardina Putri Syafeera binti Muhammad ini Azhar, and today my matrix number is 289280. Today I will be presenting regarding the High Court of Malaysia. According to Article 121 Clause 1 of the Federal Constitution, it says that within the Federal Region of Malaysia, there shall be 2 High Courts, which are firstly the High Court of Malaya and secondly the High Court of Sabah and Sarawak. Under the same clause, it is also stated that both the High Court and the inferior courts are to be subjected to the Courts of Judicature Act 1964 and the Subordinate Courts Act 1948, which are mainly concerning federal law that is applicable to this situation. According to Article 122AA of the Federal Constitution, there must be 2 chief judges, each one in one High Court. And the High Court of Malaya has minimum 4 other judges and maximum 60, while in the High Court of Sabah and Sarawak, it's minimum 4 other judges and maximum 13. Next, according to Article 122AB of the Federal Constitution, it also provides for the High Court to have a judicial commission who essentially has the same powers as the High Court judge. Therefore, the High Court has 3 jurisdictions altogether. Firstly, is the original jurisdiction, where they deal with civil and criminal matters. As for civil matters, Section 23 of the Court Judicature Act provides that the High Court is able to try civil cases where the first instance the case is tried in is at the High Court. This provided that the civil case is related to certain situation. For instance, Section 23, subsection 1, subsection A until D provides for the situation in which a civil case can be tried as a first instance at the High Court. This includes when there has been an action against a certain party relating to civil dispute. The defendant has a place of business. There are certain facts on which the dispute arose, and it may exist or be a mere allegation, or where the parties in dispute are disputing relating to the ownership of land. Next, Section 24 of the CJA provides the other jurisdictions on which the High Court is able to try upon. This includes if there is any written law which provides the ability of the High Court to try matters relating to divorce and matrimonial causes, admiralty, bankruptcy, appointment and control of infants, appointment and control of guardians, and also probate of wills. However, the only limitation which exists towards the jurisdiction of the High Court are essentially those which fall under the jurisdiction of the Federal Court under Article 128 of the Federal Constitution. This means that anything besides the jurisdiction of the Federal Court could be under the jurisdiction of the High Court in relation to civil matters. As for criminal matters, Section 22 of the CJA provides that the High Court is essentially able to try any and all criminal cases where the offences are committed that falls under their local jurisdiction, or if the offence is committed on the high seas on any ship or aircraft of Malaysia, or if the offences have been committed by a citizen or permanent resident of Malaysia on any ships or aircraft on the high seas. But that's not all. It's standard procedure for an offence to be tried by the High Court if the subordinate courts are unable to do so due to the offence being outside of their jurisdiction. This would include an offence under the Sedition Act, Official Secret Act, or as provided before when an offence is committed on a craft which is registered in Malaysia. The High Court can also hear cases in which a Malaysian citizen commits bigamy or marries someone while married to someone else. Moving on to the second jurisdiction, which is the appellate jurisdiction, the High Court is essentially able to hear any appeal cases from the subordinate courts for both civil and criminal cases and quasi-judicial bodies. As for civil cases, the appeal made cannot be for an action less than Rm 10,000 ringgit. This is, however, provided that the appeal is not relating to maintenance of a wife or children. If it is then the appeal can still be heard, although exceeding the limit set. As for criminal cases, certain limitations have been established in order to prevent the High Court from becoming overburdened with appeals. According to Section 304 of the Criminal Procedure Code, an appeal from a case where the punishment imposed was a fine of not more than Rm 25 ringgit is not admissible. Furthermore, Section 305 of the CPC states that an appeal from a criminal case in which the defendant had already pleaded guilty to a crime cannot be made, although it may be permitted if the appeal is about the legality of the sentence imposed. Also, according to Section 306 of the CPC, if an accused person is acquitted, no appeal can be made unless the public prosecutor approves it in writing. Last but not least is the revisionary and supervisory jurisdiction. It is provided by several sections in the Court of Judicature Act which give the High Court revisionary and supervisory powers. For example, Section 32 of the CGA gives powers to revise criminal and proceedings in subordinate courts. In Section 32 of CGA gives power to call for and examine records of any civil proceedings. Also, Section 35 of CGA empowers High Court with supervisory and jurisdiction. However, there is also a review of powers in this jurisdiction. Review powers of a court, or also commonly referred to as a judicial review, is the ability which in the past was vested upon the High Court to dispute on whether a certain law is in line with the Constitution or not. Article 121 of the Federal Constitution, before the amendment, used to have the term judicial power. For example, this can be clearly seen in Section 35, subsection 2 of CGA. It is able to conduct a judicial review when there is no appeal. That's all from me. I will pass the floor to Shahriz to conclude this presentation.
Thank you, Ardina, for that wonderful explanation. So, in a nutshell, the Federal Court has the same jurisdiction and may exercise the same power as the High Court. The Federal Court, in the exercise of its original jurisdiction under Article 128, Clause 1, Clause B of the Constitution, in respect of a dispute with the state or between the Federation, and any state shall not pronounce any judgment other than a declaratory judgment. Meanwhile, the Court of Appeal hears appeal from the High Court relating to both civil and criminal matters. The Court of Appeal shall have jurisdiction to hear and determine appeals from any judgment or order of any High Court in any civil cause or matter, whether made in the exercise of its original or of its appellate jurisdiction, subject nevertheless to this or any other written law regulating the terms and conditions upon which such appeal shall be brought. Last but not least, the High Court may try all civil matters but generally confine itself to matters of which the Session Court has no jurisdiction. This includes civil claims where the amount in dispute exceeds 1 million ringgit. Further matters relating divorce and matrimonial cases, appointment of guardian of infant, the granting of probate of wills and testament, and letters of administration of the estate of deceased person, and bankruptcy falls within the specific jurisdiction of the High Court. So, that is all from us. Thank you.